the beat live, you know Lil Juke made it. Yada 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 yada.
Hi, everyone. Thank you for tuning in to My Effing Body. I am your host, Demetris Neelan, a 2L at North Carolina Central University.
And I'm Mary Beth Davis. I'm also your host. I'm also a 2L at NCCU. Before we get anything going, we want to give a big shout out to our team member and classmate, Daniel McInnes, who has been working with us behind the scenes to put this interview together, taking on the roles as our researcher and reporter.
Thank you, Mr. McInnes. I want to add that we do not own the rights to the body song, but that snippet seemed very fitting for today's topic, a woman's body and her rights. Mary Beth, doesn't it seem like women constantly have to fight for their rights for their body?
Yeah, it seems like there's always a fight for contraceptive rights, the Me Too movement to protect women, and the fight for women to decide when and if she wants to have an abortion, which brings us to our topic of conversation today. Reproductive rights, specifically looking at constitutional challenges or provisions for reproductive rights.
Right. And today we have Mrs. Susanna Birdsong, the NC North Carolina Director of Public Affairs for Planned Parenthood. We also have Mrs. Liz Barber, a reproductive fellow, freedom legal fellow at the ACLU in North Carolina. These two amazing ladies are here to speak with us about women's rights around abortion and contraception that is given to us through the United States Constitution. And it's important to note that both ladies are also attorneys. Welcome, ladies, and thank you so much for joining us today.
Thanks so much for having us, y'all. It's good to be here.
Yeah, thank you all.
So let's start with you, Ms. Susanna. Tell us about you and how you came to work for Planned Parenthood.
Yeah, great question. I took a long, circuitous route to go to law school. I was a social worker for several years before I went to law school. And then after law school, worked for a couple of years at the National Women's Law Center in DC before moving back home to North Carolina and actually starting to work at the ACLU, where Liz is now. So I lobbied for the ACLU for several years on all sorts of issues, including reproductive freedom. And just over a year ago, right before the pandemic hit, I transitioned over to Planned Parenthood to lobby specifically on issues impacting reproductive freedom and also to do more sort of electoral engagement in the legislative off-season with our advocacy and political arm. Oh, I think you're muted.
You would think all this time that we would have that just down packed as much as we're on Zoom. But I was just thanking you for sharing it as an amazing journey. And what about you, Ms. Liz? What would you like to tell us about you and how you came to work for ACLU?
Sure. So after law school, I spent about 10 years in a small general practice law firm in Chatham County, primarily doing criminal defense, but counseling people through all sorts of legal issues. And I was ready for a change, and an opportunity came up at the ACLU. I was ready to get narrowed in a little bit. I really enjoyed general practice in that I got to see something different every week. But it's also hard to be a master of all trades. And so I was excited to kind of get more specific with my work, but also was looking for an opportunity where I could use the same skill set, just kind of hone it in on one thing. And so an opportunity came to work at the ACLU, focusing specifically on abortion access for people under 18 in North Carolina. I was opportunity to go and work with Susanna, who was at ACLU at the time, and I jumped on it, and that was a little bit over a year ago.
Oh, wow. That's an incredible journey as well. Thank you for sharing it. Can you tell us a little bit about what your job entails? So whoever wants to go first.
I can go first, although that's a little bit of a tricky question to answer depending on the day. And so when the legislature's in session, like they are right now, we are in the middle of a long session. So running from, January to, who knows, maybe July. They're supposed to pass a budget by July and go home, but we'll see. So when the legislature's in session, my day-to-day looks a lot more like lobbying, and in COVID times, that looks different than it usually does. Usually, if we were not in the middle of a pandemic, I would be at the legislature pretty much for part of every day, just meeting with legislators, making sure that they had what they needed, if they had specific questions on bills that were being introduced, and having, some one-on-one or group FaceTime with them, and also attending committee meetings and monitoring sort of floor sessions. I'm doing all of that right now, but mostly remotely. I do go to the legislature here and there for meetings, but most of my meetings are either by text or phone or Zoom. I'm monitoring committee meetings and floor sessions remotely. And so it feels very different. And I'm very ready to get back to, a post-pandemic reality. And when we're not in legislative session, we're always thinking about the next session and what we want to build toward, whether there are proactive policies that we can move in our sort of divided government world that we live in North Carolina, where we, still have both chambers of the legislature controlled by anti-reproductive health majorities. And so we're always thinking about what's coming next for the next legislative session and also the next electoral cycle. And so, Planned Parenthood's an organization that endorses candidates. And so a lot of the off-season work is about interviewing and supporting our endorsed candidates through their election cycle.
Wow, you're really thrown into the legislative process in North Carolina. Wow, I didn't know that
better or
about
worse. Yeah.
Ms. Lee.
So let's see. Over the last year, I've really focused my work, like I was saying, on youth access to abortion, and that has been primarily building a network of lawyers to represent young people in judicial bypass hearings, which I think we'll touch on later on in the interview. But that's been a lot of time just on the ground, finding these attorneys, training them, getting them up to speed, organizing CLEs for them, and then also the infrastructure around that. Now that requires a little less time and energy on my part, but I'm constantly kind of updating because everything in abortion is sort of a moving field. The funding changes have been significant in the last couple of months. So reworking sort of our system to take some of the stress off of the young people and finding funding for their abortions. And then just people know to reach out to me when there are different places where people need advocacy, if it is around access to a breast pump in juvenile detention, if someone who is incarcerated is being denied access to an abortion, and that sort of thing. I'm also consulting with people in other states who are working on youth access and trying to set up something similar to Text Abby, which is what we have here in North Carolina.
Oh, that's really awesome. Especially, I never thought about, abortion related to youth. So that's really interesting to find out more about.
Susanna, could you give us a little behind the scenes information about how Planned Parenthood and the ACLU came to be in like a partnership?
Yeah, there are lots of different organizations at the state level and at the national level that work on reproductive freedom, and the ACLU and Planned Parenthood are certainly two of them. And it's just been, so there's lots of synergy between our organizations, both in terms of like the issue area and prioritizing this as an issue area that we both work on, but also we are organizations that do legislative advocacy and we also litigate. And so there is and has been a long partnership around the legislative process and helping to both defend against attacks on access to reproductive health care and working in partnership to do that and to hold the line to make sure that we don't have any more bad bills that become laws in North Carolina. And then we also partner on litigation, which I know Liz is going to talk more about in just a little bit. But we are Planned Parenthood does the legislative work that I mentioned, but we also, our primary work is as a 501c3 healthcare provider. And so we are often the named plaintiff, or our doctors and clinicians are often named plaintiffs in these lawsuits. And we also have litigators that work on them, and the ACLU represents other clients, and we come together to work on that together. And so I'm really thankful at least once every day to have an organizational partner like the ACLU, and to have colleagues like Liz that I can call on and just look to for support and guidance, because we certainly need each other in this work.
Thank you for that. Liz, could you tell us, since this is a constitutional law podcast, about the constitutional right to abortion and how that was established?
Sure. So Roe v. Wade, 1973, United States Supreme Court case, was the first United States Supreme Court case to affirm the constitutional right to abortion. What was at issue there was a woman in Texas who wanted to have a safe, lawful abortion, but there was a statute in Texas that criminalized the provision of abortion if it wasn't emergency medical situation. And so that lawsuit found its way all the way to the United States Supreme Court, and the court found that the privacy right in the Constitution was broad enough to encompass a woman's decision whether or not to terminate a pregnancy or to continue a pregnancy. And that was after decades of the court finding that there is a privacy right around people's sort of like innermost life decisions, right? Around marriage, around access to birth control. So it wasn't sort of out of nowhere, but it was a whole line of cases that were led up to Roe.
And Susanna, how has or what has happened since 1973 when it comes to courts and abortion access?
Lord, what hasn't happened? It's been a journey. So I just want to mention a few cases. There are several cases where the court continued to sort of define what they meant when they said that there's a constitutional right to abortion. But really, the next time after Roe that fundamental right comes under scrutiny by the court is in a case called Planned Parenthood versus Casey, where the court said that abortion restrictions would be unconstitutional if they were, if they placed an undue burden in the path of a woman, if they were enacted for the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion. And so that was great that it reaffirmed the central holding of Roe and this right to abortion, but it was not so great in that they didn't really further define what they meant by substantial obstacle. And so what you saw in the subsequent many years after Planned Parenthood versus Casey was decided in the early 1990s was states moving to pass many restrictions and what I would call substantial obstacles in the path of people seeking abortion care. And the court didn't intervene again to really further define that until 2016 in a case called Whole Woman's Health versus Hellerstedt, where the court actually struck down two provisions that had been passed by the Texas legislature. One was a law that said that abortion providers had to have admitting privileges at hospitals that were at least 30 miles from the clinic site. And the other was a requirement that abortion clinics be certified as ambulatory surgical centers. And so required them to sort of meet the definition of a surgical center when in fact surgeries weren't taking place in abortion clinics. And these were really high standards to meet and did not actually serve a medical purpose, and were not actually, they didn't provide good evidence to show that these provisions actually increased health and safety outcomes for people accessing abortion care. And the court in 2016 in this Whole Women's Health case saw through that and said these were in fact substantial obstacles that were unconstitutional, and that going forward, if states were going to enact laws restricting access to abortion, those laws did have to have some medical basis and some attachment in reality to health and safety. And so in 2019, the court decided to hear a case called June Medical versus Gee, which at the time really concerned abortion rights advocates, because it was basically the exact same case as Whole Women's Health. Louisiana had passed almost an identical law to the law that Texas had passed, and that had been struck down as unconstitutional just 3 years before in Whole Women's Health versus Hellerstedt. But in that case, it's crazy to think about this now, was argued before the court in the last week of in-person oral arguments before the shutdown last year. It was argued on March 4th, 2020, and decided last June. And the court reaffirmed the holding in Whole Women's Health. And so that holding stands. And if states are going to enact abortion restrictions going forward, those restrictions have to actually have some basis in medical science and in protecting health and safety, and can't just use that as an excuse to put up substantial obstacles.
I'll just chime in if I can quickly that Justice Roberts was the swing vote, which was interesting in that decision. And not to be more like the downer note to Susanna, but he basically said, like, I can't overrule precedent that's so fresh, guys. Be more creative. So if you read his opinion, it's like, I don't want to rule this way, but I feel like my hands are tied. So can you guys go back to the drawing board and come up with some other abortion restrictions that we haven't so clearly ruled on? This is identical. So he actually switched his vote. In Whole Women's Health, he voted to uphold the laws, but he was the minority. He was in the dissent. So then it was just kind of interesting. It was a bit surprising, but he does have, enough respect for the law, right? And precedent to follow the precedent of the court, right? And then, of course, that goes without saying, it was in June of 2020 that decision came down, and we have a very different court today.
Yeah.
Personally, I'm thankful that they did affirm that case. So Susanna, since there's a lot of debate over whether or not the government should be giving federal funding to your organization because of the abortion services that are provided, is there any reason to not forego federal funding? And is there a constitutional basis tied to the reason you believe that?
Yeah, this is a great question. And I just want to be clear that we're not talking about like federal funding that is underwriting just like generally Planned Parenthood. We're talking about federal funding that is coming to Planned Parenthood health centers that is Medicaid money. And so this is reimbursement for services rendered, and Planned Parenthood is a safety net healthcare provider that serves a lot of low-income patients and Medicaid recipients all over the country. And so the federal funding that we provide, especially because we were pushed out of the Title X program under the Trump administration, the federal funding that we receive is all Medicaid dollars at this point. And so it, represents about just under a third of our funding, and is, reimbursement for health services. And so the basis for our ongoing participation in the Medicaid program is both that fundamentally, as a safety net healthcare provider, we think it's really important to continue to serve Medicaid patients who are extremely low income. And the Medicaid rules, it's not necessarily a constitutional rule, but the Medicaid rules themselves in statute state that states must allow any willing provider to participate in the Medicaid program unless there's evidence of fraud or criminal action, which is certainly not at play here. And then there's also a requirement in the Medicaid statute that Medicaid beneficiaries have what's called freedom of choice to decide which provider they're going to see for their family planning services. And so for those who are enrolled in Medicaid, it's really important for them to continue to have a choice about where to go to receive those family planning services. And so we are going to continue to participate in the Medicaid program and serve those patients. And I also just want to clarify, because I didn't at the top, that Medicaid does not fund abortion care currently under federal law, except in very limited circumstances around if the life of the pregnant person is at risk or in cases of rape or incest. And so for the most part, abortion is not covered by Medicaid. And what we're talking about is Medicaid coverage for other family planning services like contraceptive care and STI testing and treatment, cancer treatments, and these types of things.
So you did say that Medicaid does cover abortions in the cases of rape, incest, and when the mother's life is in danger.
That's right.
Yeah, and those are situations where a lady would need help. So that's good to know. Just kind of want to reiterate that for any of our audience that maybe Medicaid recipients and may not be aware of that. So thank you for sharing that. But in general, it does not, and that's the main.
At the federal level, some states have chosen to use their Medicaid dollars to cover abortion in other situations. And I will just say quite plainly that we advocate for Medicaid to not have those restrictions at the federal level and to cover abortion care as health care, because that's what it is. And we shouldn't be limiting it to these very narrow circumstances in which it's covered. But current state of the law, thanks to a thing called the Hyde Amendment, which is a budget provision that has been inserted in the federal budget every year since, I can't remember the exact year, but I think sometime in the 1970s.
In a while.
So for now, that is the state of play.
Okay, and so I want to ask you a question, Liz. And before I go, we've been saying ACLU, but for those who may not know what that means, that is the American Civil Liberties Union. So I just kind of wanted to make sure that everyone know what ACLU stood for. So my question for you, Liz, is what's next when it comes to the future of abortion and the Supreme Court? Like, are there any cases being taken up this term?
So it is a long pipeline that is pretty full right now. Long pipeline from, a law getting passed or the challenge being brought and then it getting up to the Supreme Court. That can be roughly like 2 years, I would say. And so it's hard to watch all of those. But I think right now, last count I heard, there were 15 abortion cases, either one step away from the Supreme Court or pending in front of the Supreme Court.
Wow.
Those cases range from just straight up abortion bans to restricting and regulation such that it would just result in would result in massive clinic closure. At the very beginning of the pipeline, we have I think tomorrow will be 2 weeks since the governor in South Carolina enacted a heartbeat bill, which essentially says once there's a detectable heartbeat, which is 6 weeks, right? So just for people who perhaps haven't been pregnant or aren't familiar with pregnancy is not measured from when you get pregnant. Pregnancy is measured from the first day of your last menstrual period. So when you, like the earliest, like if you get a pregnancy test, the earliest it says that you should take it is a couple days after you've missed your period. At that point, you're about 5 weeks pregnant. So 6 weeks pregnant, especially if you are not trying to get pregnant actively, most people don't know they're pregnant at 6 weeks.
Right, and it may not be able to come up with the money so fast.
Absolutely. So it's essentially an outright ban on abortion. So that was signed by the South Carolina governor, and it was effective upon his signature. That was 2 weeks ago tomorrow. And then Planned Parenthood, along with maybe the Center for Reproductive Rights, immediately filed a lawsuit, which was heard the next day. And federal district court judge did sign a temporary restraining order. But that's just at that end of the pipeline. We'll see where it ends up. And then there are many cases further down the pipeline, and some that should be heard soon by the Supreme Court. But I won't read the tea leaves to see what the next big case will be.
And it's so amazing that it keeps going to court, because you would think, double jeopardy, but that doesn't apply to civil suits. But
Yeah, and I think they're just hopeful, new court, new ruling, right? Because there's no question that under existing Supreme Court law, a ban on abortion after 6 weeks is unconstitutional. I mean, full stop, it's unconstitutional, right? And South Carolina is just one of many states who are trying to pass these laws, and are in fact passing laws that are just so blatantly unconstitutional.
well, hopefully you have some precedent that will be in your favor, and use it to kind of eliminate the number of cases. The next thing I wanted to ask was, what does access to abortion look like in North Carolina right now? And that's to whomever wants to answer that.
I can jump in with that, and then Liz, if you want to talk about the lawsuit access to abortion in North Carolina right now, I would say that we have several substantial obstacles in our state law right now that impede access to abortion. And many of these were passed just in the last decade. So in 2010, there was sort of a seismic shift in the makeup of our General Assembly. We had a legislature that was, for the first time in a long time, controlled by anti-reproductive health majorities. And for 4 years of the last 10, an anti-reproductive health governor too. And so over that period of time, we saw really an avalanche of new restrictions pass and become law, including, I would overwhelm you if I named all of them. I'm happy to send y'all afterward if it's of interest. There's a chart that is a sort of picture representation of all of the restrictions in North Carolina.
Yeah,
But I'll just lift up, okay, I'll send that to y'all. I'll just lift up a few that I think are sort of the most egregious when we talk about actual barriers to access. And so that includes a biased counseling script that is state mandated, that has to be read to a person before they access an abortion. After that script is read, and there are no exceptions to who hears it. And so for whatever reason you are seeking an abortion, you have to hear things like, there may be funding available to you to help you raise a child, even if you are accessing an abortion because of a lethal fetal anomaly, and there would be no child after birth. And you have to hear things like the father of the child is responsible for and would be responsible for child support. And you have to hear that even if you are the victim of rape or incest, and the father of the child is not somebody that you ever want to think or hear about ever again. And so I just want to emphasize the coercive and heartless nature of this script. And so that is read to the patient in every instance. And then that sets a clock running for 72 hours. So we have one of the longest waiting periods in the country. We require people to wait 72 hours after they've been read this biased counseling material before they go to their appointment and access abortion care. And this is really demeaning, I think, because it just suggests that people who have decided to have an abortion really need to sit and second guess that opinion and that decision before they access healthcare. And in no other instance of healthcare do we require people to sit and think for 72 hours before they do that. So in the case of a colonoscopy, in the case of a vasectomy, we don't require the same mandatory delay. We also have laws on the books that say that only doctors can perform abortions, which really limits access because we know that 91 out of 100 counties in North Carolina currently don't have abortion providers in them. But we have nurse practitioners, physician's assistants, and certified nurse midwives all over the state who it is within their scope of practice to perform abortions, especially in earlier stages of pregnancy. We just say in our state law, they are not allowed to do that. So that really limits access for folks. And then just a couple of other restrictions that I'll mention include a ban on telemedicine, abortion care. And so prior to 11 weeks of pregnancy, you can access a medication abortion, which is much less invasive and just involves taking 2 pills. And that is something that can be counseled on and prescribed just on a Zoom, just as we are doing here. And we require patients to come in and do that counseling and prescribing process in person in North Carolina, which I think in this current pandemic moment in which we find ourselves is all the more noticeable how unnecessary that is and how it really puts people in harm's way to have to interact in person with folks when they wouldn't otherwise have to. And then there was one more that I wanted to mention. What is it? Oh, we have what's called targeted regulation of abortion providers, or TRAP regulations on the books in North Carolina, which are sort of the same as the law that I mentioned that was challenged in Texas, although ours don't go so far as to require our clinics to meet all the certification of ambulatory surgical center, but we do have arbitrary things in regulation that say that we have to have certain width of hallways and we have to have certain ventilation systems, and we are regulated in a much more stringent way than is necessary for the types of procedures that are happening in our clinics. So I'll leave it there, but there is a web of restrictions that exist in North Carolina that really limit access to abortion on the books right now.
So I just want to make sure I heard you clearly that midwives have the training to perform abortions, and you said another type of medical person besides doctors.
Certified nurse midwives and nurse practitioners and physician's assistants, it's all within their scope of practice to do things like provide management of miscarriage, which in many instances looks exactly the same as an early stage of pregnancy, what's called an aspiration abortion. And so the care provided looks the same, but because one is miscarriage management and because one is abortion care, the law says that they can't provide abortion care, although they can do miscarriage management.
And you also
medication abortion, it's just giving somebody a pill, which
Right.
they do all the time in all sorts of different contexts.
They can literally prescribe the same dose of the same medicines for miscarriage management, but they can't do it for an abortion. It's crazy.
And didn't you say that also they have restrictions on like just the way your office is set up? You got to have a certain ventilation. You have a size of a hallway, but they don't
have a snack room.
Snack room.
Have a snack room.
But they don't do that for a normal Wake First clinic or something. Oh, okay.
Nope. We are the only type of clinic that is regulated to such a degree. For no medical, there is no medical basis for requiring all of those regulations.
So I have a question that wouldn't that be an unconstitutional burden on you guys to have?
Yes.
Mary Beth, what a great question. Liz.
And that's exactly why Planned Parenthood and ACLU and the Center for Reproductive Rights brought a lawsuit representing the Planned Parenthood clinics, a woman's choice clinic. They have 3 different locations in North Carolina, several abortion providers, and would-be abortion providers, but who aren't able to provide abortions because of the restriction on advanced practice clinicians, certified nurse midwives and nurse practitioners. So we brought that lawsuit. We filed it in and Sister Song, very important. We brought that lawsuit in September of last year, and we are challenging 5 different abortion restrictions. They're really the same ones that Susanna just enumerated. The biased counseling requirement, the 72, and the biased counseling requirement, informed consent is an important part of any medical procedure, right? I mean, you go to get your tonsils removed, you go to get a COVID vaccine, right? You go for any medical procedure and you have to get informed consent, right? Both by like the doctor's standard of care and by law, you're required to. There's only one medical procedure where the state legislature in Raleigh, not doctors, have decided what has to be included in that informed consent. The 72-hour mandatory delay, it's just demeaning to our ability for them to question that we don't actually know what we want to do with our own bodies, right? Only medical procedure that has a mandatory delay. North Carolina, like Susanna said, we share the honor with a few other states, I think Missouri, I can't remember who else, of the 72 hours. Some states don't have any sort of mandatory delay, and other states have 48 or 24 hours. In addition to those 2, we challenged the advanced practitioner ban. In Virginia, if you are a medical professional and it is within your scope of practice, you have the training to provide an abortion, you can provide an abortion. The American Medical Association backs up these qualified medical professionals to provide this care. Telemedicine ban, same thing. AMA, American Medical Association, all sort of the big organizations who pay attention to what the science says and are actually doctors, they all support our position on this, that it's okay for these people to provide this level of care. And then also the TRAP scheme, like Susanna was talking about. And just so people can like really wrap their heads around how ridiculous this is, for a medical abortion, North Carolina law requires that the person be physically present with the doctor for the doctor to observe them swallowing pills. I mean, in case they choke, right? I mean, why? Pills that aren't going to have any effect on that person's body until hours later. Same thing, the hallways have to be a certain width, purportedly to protect the woman's health in case an ambulance and they need to run in a stretcher because you just had a complication swallowing a pill. Like what? It doesn't make any sense, right? It's crazy. So all of these are roadblocks that aren't based in science. They aren't based in medicine. They are designed by the legislature specifically to limit access and to push access out of reach for many North Carolinians. So we filed a lawsuit challenging them under the North Carolina Constitution, saying that they are violations of equal protection of laws and that they are violations of North Carolinians' right to happiness, to liberty, to the enjoyment of the fruits of your own labors. And it is at the very beginning stages of the lawsuit, and our first hearing is coming up. It is 2 weeks from tomorrow in Wake County. It's a motion to dismiss filed by the defendants. And so right now we're just in front of one judge, but an interesting North Carolina fact is when you have a facial challenge to a statute, a constitutional challenge to a statute, after you make it through that initial stage, then it gets assigned to a 3-judge panel. So it'll end up in front of 3 Superior Court judges hearing the case.
Well, I heard you were arguing under equal protection this time, not privacy. The abortion rights were initially argued under privacy, but you guys are going to go under equal protection?
Yes, that's right. And I'll be happy to share the complaint with you all if you're interested in seeing it. It's a long one, but it's some good reading.
I actually am kind of interested into whether the case, like the courtroom that you're going to be in, would be open to the public. Just in case we were to pop in and check it out.
Sure. And it is going to be argued via Zoom or WebEx rather. And so the court calendar, if you go to the North Carolina AOC website, which is Administrative Office of the Courts, and go look at the Wake County calendar for Civil Superior Court the week of the 15th, because they do the court calendar for Superior Court by the week, there is a WebEx link in there. And so anyone can drop in and listen to those arguments.
Thank you so much. So we only have
And
about,
sorry, I do want to get back to something that Demetrius said that I don't think we've fully, like, we've talked about how ridiculous these requirements are, but for someone like me with flexible work hours and a car and stable childcare, and I live a few miles from Planned Parenthood, these restrictions honestly don't really affect my ability to access abortion. But let's picture someone in, I'm just going to pick on Ashe County, North Carolina. They are hours from an abortion clinic. Maybe they don't have regular childcare. Maybe they are an hourly employee. Maybe they don't have a car. They don't have public transportation in that part of the state. And so instead of being able to call a clinic on the phone, right, a clinic in Winston-Salem, and be able to get that care of telemedicine, instead of being able to go to their local healthcare provider, right? Just the person they would go to if they had strep throat or an ear infection or whatever else, and getting this care, they have to figure out childcare, they have to figure out transportation and get themselves several hours. So there really is a disparate impact based on where you live and your access to transportation and how much money you have in your bank account and all of those things. And sorry, but growing up in North Carolina, I guess I didn't realize how easy abortion access could be and should be. And I have a good friend who is an abortion provider, and she did her training in New York. And she said, you know, someone might come in, an existing patient of hers, right, who she has a relationship with, and they're not feeling good. And she figures out they're pregnant. They decide they want to terminate that pregnancy because of whatever life situation they're in. And she gives them an abortion just then and there, right? Like, it just doesn't have to be where this crazy world we're living in North Carolina. And now I'll let Susanna talk.
actually, I was gonna say, as a North Carolina native myself, I didn't realize until I started doing the research behind this podcast how difficult it would be for me if I had wanted to get an abortion whenever I was in high school. I'm from Shelby, North Carolina, which is a Cleveland County. It's in the middle of nowhere. I didn't have a car in high school. I didn't have, anything that would have, helped me get to where I need to be to get an abortion. So it really, I guess, whenever you're growing up here, you don't realize how hard it would be to get some basic liberties or fundamental rights for yourself that you could get somewhere else in another state. And I guess that kind of goes to like the privileges and immunities that other state citizens are enjoying versus us that we can't enjoy. So I just put that 2 cents out there, but we have about 10 minutes left. So I wanted to get to some of the other questions that we had on the list here. So this one is for Susanna. How do the issues of reproductive freedom and religious liberty interest intersect? And how might those intersections show up in litigation in cases and legal arguments?
Yeah, this is a fascinating question, and we don't have to spend a lot of time on it because I know we don't have a lot of time left. But as a thought exercise for constitutional law scholars, I will just say, the Constitution is a document that protects both religious and reproductive freedom. And so it's really, of course, you'll know this, about reining in the power of the government to control the people. And so we have the First Amendment, which protects religious freedom and says the government can't establish or promote a religion. And the right to privacy, found in many different amendments, and in the penumbra, it says the government doesn't have a say in many things, including whether I use birth control and whether I decide to exercise my bodily autonomy and have an abortion, especially in the earlier stages of pregnancy. So abortion rights have not ever been vindicated on First Amendment grounds, but there is an interesting argument to be made that, I don't know, maybe one day they will be, maybe they could be. So if the government endorses a particular conception of when life begins, it is arguably violating the Establishment Clause by favoring certain religious viewpoints or religion over non-religion. And so this is an argument that has been brought up in briefs over the years, and hasn't, like I said, hasn't been directly sort of litigated. And most attorneys at this point would say probably a non-starter. But it's interesting to think about these two freedoms in the Constitution, because in many people's minds, I think we think about religion, that there's this tension between religion and religious expression and access to abortion. And that doesn't necessarily have to be. And in fact, I think these two freedoms in the Constitution are actually reinforcing of one another when it comes to what the government has the power to prescribe. And then I'll just, on the last point, note that research has consistently shown that the majority of people who obtain an abortion in the United States have a religious affiliation. So while there's this narrative of tension between these two things, abortion rights and being religious, that you can't be both religious and supportive of abortion access and rights, I think that is a false narrative and a dangerous narrative. And in fact, both can be true. And I'll speak from just a point of personal privilege for a moment to say that both are true for me. I am a supporter of abortion access, of course, and I also consider myself a person of faith. So I would say there's a lot of work that we need to do in sort of the narrative around those two things, but they coexist.
That's a really good point, Susanna. Like they can coexist in the same realm. Before we close out, I did want to ask one question for Liz, because I really wanted to know, you have focused your work on the youth access to abortion. So earlier you told us and Susanna generally about the constitutional right to abortion. Is that a right different for young people? And if it is, how?
Yeah, so that's a great question. After Roe, there are all sorts of states passing restrictions on abortion. And one of those was restricting access for people under 18. And so it was, I believe it was a Missouri case, Planned Parenthood versus Danforth, where Missouri was requiring parental consent for anyone under 18 to get an abortion. And there's some great language in there where the court struck it down and said, listen, constitutional rights don't just magically appear when you're 18, right? Like you don't have them, you don't have them, you don't have them. Oh, now you have them, right? And they said that you could not require parental consent outright, because that would essentially be substituting the parent's judgment and the parent's beliefs and the parent's decision for that of the young person. And that was it's the young person's right. It's not the parent's. A few years later, there was a case, Bellotti versus Baird, where the law challenged there required parental consent, but it allowed for a young person to petition a court to waive that requirement. The court said that is okay. So you can require parental consent as long as you also have sort of like a release valve, right? And that is called judicial bypass or judicial waiver. So there are 38 states that require some sort of parental involvement. We call those forced parental involvement laws, either parental notice, just so the parents have to be told, but not necessarily consent. And then there are consent states. There are other states where the decision whether or not to terminate a pregnancy is solely of the young person, and the young person can make that decision and consult whoever they want to consult. You can't legislate good family dynamics. If you could, then we would live in a very different world, right? If the legislature could pass some laws and all of a sudden like domestic violence would go away. What we see looking at states that don't have parental involvement laws and states that do is that young people have abortions at about the same rates, that young people consult parents and trusted adults at the same rates. So whatever it is that they were thinking that they might accomplish with these laws, they are not. What we do see as a result of these laws is more young people traveling across state lines in order to get an abortion. For instance, young people in North Carolina Closest place to go is Washington, D.C. So if you have the means, if you have the car, if your parents aren't going to wonder where you went for the day, then you can travel to Washington, D.C. and get an abortion without talking to your parent, without your parent knowing. We also see more terminations at later stages of pregnancy because it takes, I think, the young person longer to figure out how to do it, right? But there's some young people who just aren't in a position to consult a parent. Either there is physical abuse going on, the parent has told them, I will kick you out if I find out you're pregnant, I will kick you out if you choose to have an abortion. There are a lot of young people who are already parenting and went that route the first time, told their parents, and the parents refused to let them have an abortion, and they know that they're not ready for a second child. And so for North Carolina, the ACLU of North Carolina partnered with Carolina Abortion Fund and launched Text Abby, which is a text line for young people seeking abortion care in North Carolina, where they can text in, ask questions about access. We are not options counselors. We don't help people figure out what they should do or want to do. That's entirely their decision. But once they've decided on abortion and have decided that they're not in a position to get parental consent, then they reach out to us, and then we connect them with a lawyer to help them navigate the judicial waiver process. So it's really intimidating, as you can imagine, being 15, 16, 17 years old, walking into a courthouse and filing a legal document and going through a hearing on your own.
Well, I just want to say thank you guys so much for coming and participating in our podcast. This was a really enlightening conversation. I personally feel like I learned a lot. I think this is a very interesting topic, a very unjust topic as well. Hopefully, as we move forward as a nation, we'll be able to overcome these constitutional barriers. And one day there will be a future where women truly do have like rights to their own bodies. I just want to say thank you to everyone who's viewing and tuning in and listening to our podcast. We do appreciate your feedback. Please feel free to leave us questions, comments, and concerns within the comment section below. Have a wonderful weekend.
Thanks, y'all.
Thank you all.